then I wish a good afternoon, a good morning, a good afternoon, a good evening, even to all the participants. A great pleasure to welcome you all to the WIF 21, the World Investment Forum number 7 in the year 2021, and in particular to the high-level International Investment Agreements Conference 21. Of course, looking into the issue of international investment treaty making in the new era of the global economy. And with that, it's my pleasure to give the floor to the Director of the Division on Investment and Enterprise here at UNCTAD, Mr. James Shan. James, you have the floor.
Thank you, Jörg. Excellencies, distinguished panelists, ladies and gentlemen, so happy to see so many friends join us for this panel. And some of you have been instrumental even contributing to the work of UNCTAD's IA programs, for instance, Anna, so happy to see, and also Lisa, and also from OECD, and others, cannot mention all of them. But welcome to our high-level IA conference, entitled International Investment Treaty Making in the New Era of Global Economy. This is one of the highlights of the 95 events for this week that we're organizing in the framework of the World Investment Forum. UNCTAD has been working on the reform of the IA regime for over a decade now. We started at the time of the investment development paradigm shift immediately after the last global financial crisis. Of course, we have been trying to improve the system, working with OECD, with ICSID, with UNCITRAL, over many years. But I would say the real reform that we advocated in a holistic approach started a decade ago at the time of the paradigm shift. So many participants in this conference bears the witness to the fact that UNCTAD is not alone in doing so, and that we provide a truly inclusive forum bringing together governments, international organizations, private sectors, civil society, and academia. The health of the current IA regime lies in the eyes of the beholder. Regardless of what one makes of its current state, the existing regime was conceived, designed, and implemented in past times under very different economic, social, and political circumstances. Sustainable development imperatives were not present in the discussion when the treaty making took place or intensified 20, 30, or 40 years ago. So investment protection at that time was the key objective of the treaty making. Nowadays, the pendulum is swinging back away from the pole of protection and liberalization, moving towards the middle, with regulation gaining importance. UNCTAD has been assisting countries to effectively reform their old treaty regimes, with over 1,000 government officials trained on key IA issues since 2012, and 75 countries and regional organizations benefiting from UNCTAD's IA and the model-based reviews. We are at the forefront of the modernization efforts together with other organizations. To support and accelerate ongoing IA reform efforts, UNCTAD launched this IA Reform Accelerator to assist the states to modernize the existing stock of old generation investment treaties. It operationalizes the idea of gradual innovation by focusing on the reform of the substantive provisions of IAs in key areas. And this brings me to the topic of our first panel today, the status quo of reform. Modern IAs send a clear signal. Governments around the world want reform, and every year, the World Investment Reports analyze its recent treaties. And it exhibits many of the new generation features that UNCTAD has advocated for the reform in these tools. We also observed several related trends. Bilateral investment policy making slows down. That's one. And there are fewer new treaties at the bilateral level. And in addition, we also see the existing bids are being terminated or consolidated within regional agreements. Another important feature is that acceleration of regional rulemaking, and that may well turn out to be a kind of tectonic shift in the geography of the IA landscape. The increasing number of mega-regional IAs, on the one hand, creates a multitude of bilateral relationships, and on the other hand, has geopolitical impacts beyond the investment rulemaking. Importantly, all of these new mega-regionals contain innovative and sustainable development-oriented provisions. We have made significant progress in creating a new generation of IAs. However, old generation IAs persist. Over 90% of the treaties in force today were signed before 2010. And the overwhelming majority of those treaties, overwhelming majority of those kind of known cases, according to our statistics, is about 1,100 known investor state arbitration cases that they have been initiated under the IAs signed before the turn of the millennium. This is all known to you as experts. The ISDS is symptomatic of a wider problem. The proliferation of ISDS cases may have caused the backlash against the existing regime. So the reform that only focuses on procedural elements of the ISDS does not go far enough. So it is important, and we know, but more is needed to be done. And this brings me to today's second panel, how to accelerate the current IA reform efforts. Multilateral consensus building continues to be a formidable challenge. UNCTAD remains committed to support this process, and bilateral and regional actions also shows promising progress. The task now is to quicken the pace, move from the current sluggish walk to a fast run. And also we need to bear in mind over the past couple of years, I have to say, the kind of a drastic change of the global political economic context. And that may have significant bearing on the future treaty making and policy making in general. And that may have fundamentally changed, perhaps, of our thinking of the new generation of investment treaties and to adjust our existing tools and frameworks, including our roadmaps for reforming international investment regimes. So it is my hope that today's IA conference will continue our efforts to move forward in the journey of modernizing the international investment regime in this new era of globalization. Before I conclude, I wish to thank Jörg Weber, who has been directing the IA program, and also to Hamid managing it at the moment, and Diana and other colleagues who have been working very hard, including pull off this important events. Thank you. Back to you.
Thank you very much, James. We will now begin with the first panel. Let me hand the floor to our moderator, our first moderator, Ms. Samira Sulimanovic, Head of the Department for Bilateral Trade Relations, Bosnia and Herzegovina. Samira, you have the floor.
Well, thank you very much. First of all, welcome everyone. For this panel, we will focus on taking stock of the reform of the IIA regime. But before we start, I would like to add a few sentences. Maybe we cannot pinpoint exactly the time when the IIA's regime reform started. But at the IIA's high-level conference back in 2014, I remember hearing some voices in the room questioning at all the need for reform. Ever since, the small snowball of reform that we started to roll then became kind of avalanche that significantly changed the landscape of the IIA's regime in the world. The reform avalanche certainly made also some damage along the way, but in my view, that never brought into question the need, the substance, or overall results achieved to present. The work is far from done, since, as we have learned from the process, there are many layers below the surface. Experts from all over the world gathered in this joint endeavor, invested their best knowledge, experience, and enormous amounts of time and energy. Thanks to them, we have got this far. I am pleased to have some of them today with us in the panel. UNCTAD, on the other hand, not only presented an all-inclusive platform for discussion, but its IIA's team tirelessly worked to support us and assist us in so many ways. Dear colleagues and friends, thank you for being today with us. Now, every panelist will make a short initial statement of 3 minutes. We will start with organizations and then continue with countries. We will follow the speaking order in the program. May I kindly remind all the speakers to please stick to allocated 3 minutes of time. Let me now introduce our first speaker. It's Mrs. Emily Mburu Ndoria, Director in the Directorate of Trade in Services, African Continental Free Trade Area Secretariat. Mrs. Mburu Ndoria, where do the negotiations stand with respect to the investment protocol of the African Continental Free Trade Area? And what are some of the reform features that we can expect to see in the investment protocol?
Okay, thank you very much. And I'm so happy that we were invited as the AFCFTA Secretariat to this forum. And we are happy to come to an UNCTAD forum as always. And on behalf of His Excellency Wamkele Mene, our Secretary General, we are happy to be with you today. Let me start with first thanking UNCTAD that have been an invaluable partner to the AFCFTA Secretariat, as well as to most of our member states of the African Union for their provision of technical assistance in the development of investment-related policies, capacity building support, as well as global overview and benchmarks of some of the policy directions that could be considered as we develop here at the AFCFTA, the Protocol on Investment. Now, the protocol is being negotiated with the broad objectives of the African Union Agenda 2063, and that is to transform African economies and increase intra-African trade through boosting productive investment within the continent, thus increasing the diversification of goods and services to trade within the continent. Now, we have commenced our work in the development of the protocol, and this is in line with the directive that we have been given by the extraordinary session of the Assembly of Heads of State and Government of the African Union, held in December of 2020 virtually. The Committee on Investment has also been established, and this is through our Council of Ministers responsible for trade earlier this year around May. And the committee has also started working, and they have developed and adopted their terms of reference, and most importantly, the negotiating modalities and the guiding principles for the negotiations of the Protocol on Investment. And here maybe I can mention that 2 colleagues who are helping us with this work are with us today, Professor McCann and Dr. Susie, whom you know very well. So they are also assisting us with this work in terms of developing the Protocol on Investment under the AFCFTA. The Secretariat has also facilitated, and here this is where UNCTAD has also come in to assist with facilitating capacity building engagements and regional stakeholder engagements. And we have received views on the potential issues for inclusion in the protocol. And additionally, preliminary work on the protocol on investment has also been done, and discussions held in the Committee on Investment to identify what are the key elements and possible focus areas for negotiations. And this is in line with the state's needs while building on the initiatives and developments in state parties. And maybe here I can mention that once you sign and ratify the AFCFTA agreement, then we call you a state party. So you will hear us mentioning state parties here and there. And also we have taken into consideration work that had already been done at the continental level and also under the regional economic communities in Africa. Now, moving on to then your second question in terms of the reforms that are envisaged. Here, the Secretariat has very clear objective, and that is to ensure that the protocol investment must have provisions that work for Africa. Therefore, the African continent as a hub of investment governance innovation, and here we will hear maybe from other speakers on the substantive issues that are in some of the work that, or the investment treaties that are among African countries, such as those related to fair and equitable treatment and investor obligations, among others. The AFCFTA protocol also presents an opportunity for the continent to innovate once more. And this is in respect of important procedural issues, such as including investment dispute settlement, where Africa will provide a very unique voice in this area. The protocol on investment will also establish a modern and coherent continent-wide legal framework for the promotion, facilitation and protection of intra-African investment, while safeguarding the regulatory space of our state parties. The protocol on investment under the AFCFTA is also expected to build on the initiatives at the regional economic level and also at the individual member states level. And so we hope that the negotiations on the protocol on investment will seek to better integrate the highly innovative regional and continental approaches, and most importantly, will be the need to address both the promotion and protection of investment with a view of balancing the country's developmental needs and also those of the continent, and not forgetting, of course, the investors that will be coming into Africa. So maybe as I finish, I can say that with respect to the differences and the diversity of investment treaties of African countries, it is significant to point to the fact that there are more convergences within the network of African regional investment agreements than we can talk about inconsistencies. And thus it is fundamental to assess how these convergences can then translate into effective provisions of the protocol on investment. And here maybe to mention the Pan-African Investment Code, which will definitely serve as a template and guidance for the negotiations and in the drafting of the protocol. So we expect that the protocol on investment will bring coherence and consistency in the existing regulatory framework that we have across the continent. And of course, moving ahead, we will continue working with UNCTAD and in the continued support from them as we negotiate this very important protocol together with other strategic partners and colleagues present here. So for me, that is what I would want to say for now on the protocol. Thank you very much for your kind attention.
Thank you very much, Mrs. Mburu Ndoria. I know 3 minutes are extremely short, but I really kindly ask you to stick to the time that we have, so we have time for all the speakers that have been foreseen on the list. We will now hear from Mr. Urban Rusnak, Secretary General from the Energy Charter Secretariat. Mr. Rusnak, the process to modernize the Energy Charter Treaty is ongoing. Where do we stand after 6 rounds of negotiations?
Thank you very much, Samira, for introducing and for asking this question. Indeed, the Energy Charter Treaty is the agreement which is responsible, was mostly invoked international investment protection agreement in the world. So we are counting something like 150, up to 150 known cases within the framework of the ACT. In view of the limited time, I will provide you with a very brief overview where we stand. You will be able to find more information on expected report to the Energy Charter Conference, which is due to be released by end of this year. We expect to have more clarity after the ministerial session of the Energy Charter Conference, which is scheduled for the mid-December in Yerevan, Armenia this year. The topics which are discussed are very broad, varying from purely energy-related issues such as transit of energy resources to investment protection standards or sustainable development and obsolete provisions of our treaty, which have been signed back in 1994. We are in a comprehensive exercise to modernize the ECT. To date, the modernization group held 7 rounds of negotiation. A bit update for you of the 6, but we are already on the 7th, and the 8th one is looming in November. We held all the meetings online, pandemic obliged. Sorry for this. Negotiators have a tough time behind the small screens, but we really hope that we'll be able to hold at least one meeting this year in person. All the topics which were addressed during the negotiation were addressed more than once, while the definition of the economic activity in the energy sector has been discussed in every single meeting in 2021. The negotiators are looking for the needed flexibility. This is one of the key elements of the story of the modernization of the ECT. Furthermore, a few informal workshops on particular subject matters were organized in between the formal negotiating rounds. The modernization of the ECT is a member-driven process. The political desire of the contracting parties warrants its success. As Energy Charter Secretariat, we are the neutral body. We are supporting our contracting parties, delegates, and we ensure the technical means and facilitating the negotiation, providing the support and acting as a sort of mediator, trying to approach diverging opinion, ensuring the comprehensive proposals to help contracting parties to focus and to find a common language. I'm proud to announce that most of the topics are currently discussed based on the draft compromise proposals that the Secretariat was entrusted with drafting. So I praise my legal team, by the General Counsel Alejandro Carballo, for this hard work they're doing in supporting the contracting parties. A reasonable progress was made overall, with some topics already considered as tentatively concluded, and with considerable progress reached in others, such as definition of investment, investor, indirect expropriation, as well as on denial of benefits. According to the modernization mandate, any decision, including procedural issues, should be based on consensus, aiming to reach the highest possible degree of convergence among the participants. The treaty has more than 50 contracting parties, so this is really a pharaonic exercise. Therefore, to bring the modernization process to this successful completion, the contracting parties should keep negotiating based on the goodwill, with the understanding that nothing is agreed until everything is agreed. I wish all of us today an excellent continuation of the event. I'm looking forward to hearing you about the positive discussion and outcomes of today's conference. Thank you very much.
Thank you very much. I will now give the floor to Mr. Carlo Pettinato, Head of Investment Policy Unit in the European Commission. Mr. Pettinato, what are the key reform elements and priorities for the EU in its new investment agreements with third countries and with developing countries in particular? And what are the opportunities and challenges going forward?
Thank you very much, Ms. Suleimanovic. Good afternoon to all colleagues. Very happy to speak about the reforms that we are pursuing on our investment policy in the agreements, of course, with developing countries, but not only. And I think this is a very timely moment to speak about this. What we're trying to do is, in the end, is to encourage and to make sure that the conditions for foreign direct investment are the best in order to reach the sustainable development goals, but also in the recovery of the post-pandemic, this becomes even more pressing today. What have we done? Since 2015, we have adopted what we call the reformed approach, at EU level. The European Commission negotiates for the European Union on behalf of the European Union. So, and all the member states are included in this reformed approach. We have substantially reformed the way we draft the protection standards. We have introduced what we call the right to regulate the regulatory space for governments to achieve legitimate public policy objectives. And we are pursuing this approach in all ongoing bilateral negotiations where we do have investment protection, such as now Chile, with Indonesia, and also in those that have already, where we have concluded the negotiations with Canada, Singapore, Vietnam, and Mexico. So when these agreements will come into force, they're concluded but not yet into force, they need to be ratified. When in force, these agreements will replace at once 57 older generation bilateral investment treaties of EU member states that were concluded well before 2010. So we're contributing in the rationalization of the old BITs. And of course, Dr. Rusnak just mentioned the ECT. We have been pushing for several years for modernizing this agreement, which is indeed, as we all know, I think by now, the most litigated investment protection agreement in the world by far. And there is an urgent need to reform its old standards. And as far as we're concerned, also to make this agreement fully compatible with today's new goals in terms of energy transition and climate objectives. This is an absolute necessity for the European Union, who is really at the forefront of these negotiations. We have presented proposals on all the topics, and of course all our proposals are public because they're published in our website, so everybody can see what we are proposing there in the Energy Charter Treaty. So we do hope that yes, there's been some progress. We do hope that the ambition will be matched by the other parties. Beyond investment protection, we are now focusing more and more also in the area of investment facilitation in our agreements, in our bilateral, but also in the multilateral. So developing countries in particular stand to gain a lot from such facilitative measures aimed at improving and simplifying the investment climate to attract much needed investment. And we are negotiating the first bilateral investment facilitation agreement with some African countries who have expressed interest, and the first one is Angola. UNCTAD reports of the increased adoption of such investment facilitative measures, for instance, the e-platforms, by governments in response to COVID. So this goes in that direction. And these agreements are very much linked to the cooperation activities that we have with these bilateral with these countries. And the European Union is actively participating, of course, in the WTO negotiations on investment facilitation for development. We have presented comprehensive proposals on all sections of the agreement. Now, there are almost 2/3 of members of the WTO membership. There are 105 so far, including many developing countries that are participating. This was an initiative brought by a group of developing and emerging countries. We believe that this initiative can contribute to the SDGs and the post-pandemic recovery. Special and differential treatment and capacity building for developing countries for implementation are clearly cornerstones of this initiative. We fully support that. So we think that UNCTAD will have a role and should take an active role in the implementation of this agreement once concluded, given its experience of assisting developing countries on the ground. Finally, On dispute settlement, of course, we will hear much more now. In UNCITRAL, there is a lot of interest in the Working Group 3 in the creation of a permanent mechanism to address the various problems affecting ISDS. The EU has pushed very, very strongly to encourage this fundamental reform of the ISDS system. We think there is a willingness to advance the talks to ensure a permanent mechanism that can start functioning as soon as reasonably possible. The EU and its member states are committed to the establishment of a multilateral investment court, which will complete the process already started, that we started bilaterally in our agreements with Vietnam, Singapore, Canada, with the creation of the investment court system. So finally, I note that in all the fronts of international investment agreement reform, mentioned even in the recent World Investment Report, in the ECT, as regards the termination of the intra-EU BITs, investment facilitation in WTO, and UNCITRAL, we are very much acting, participating. So what is the challenge? The challenge, I would say, is we hope our partners will have the same level of ambition in order to have investment policy at the level of the challenges we face today. Thank you very much.
Thank you, Mr. Pettinato. We will now hear from Mrs. McKinnon, Secretary General of ICSID. Mrs. Kinner, ICSID is engaging in a reform process of its rules. So how would you rate the level of appetite for procedural reform? And is there agreement on the direction that this reform should take?
Thank you very much, Ms. Sulejmanovic. And it's lovely to see all my colleagues at UNCTAD after such a long time with us being at home. The level of engagement in the ICSID rule amendment process has been absolutely tremendous. And this is true not only with respect to the dialogue among states, but also dialogue with the legal profession, academia, and other interested groups. So this has literally been our most comprehensive and our most transparent process to date. By way of some background, we started it in late 26 and early 2017 with a scoping process. And I can tell you that we were even surprised at how broad a list of reform topics came out from that scoping process. So we took on almost all of those to the extent they would fit into the ICSID rules and developed a working method essentially of getting comments, doing a working paper with the proposed change or amendment, explaining how it would work, and then having an in-person week-long consultation with our member states and numerous presentations with civil society. And we've done that process all the way through. And we are at the point now where we have finished our 5th working paper. And frankly, the first one was a telephone book size. We are now whittled down to a very, very short, slim volume. And we have really literally about 4 or 5 final issues to close on. So we hope that we will be closing the consultation stage by the end of this year and sending this product out for a vote by our member states. There was a huge amount of consensus on a lot of areas, and that obviously helped us to get to this result at this point. One of the biggest issues for everybody was trying to reduce the time and cost of arbitration, and we've come up with a number of mechanisms, things like expedited arbitration, case management conferences, reduced timelines. So I think this will certainly address that problem. But one of the difficult things there is that many, including states, often said, I almost need more time. This is a complex process. So the overall systemic interest in less time, but the interest of individual participants who have a lot on their hands when they do a case was something we had to balance. We also saw a lot of interest in expanding the range of dispute settlement tools. As you know, more than 95% of the cases have been arbitration. And there's real interest now in looking at other potential tools. So we have completely updated our conciliation rules and our fact rules. And we have put together what I think is the highlight here, which is a set of standalone mediation rules for investor state arbitration. And I hope that participants will start using those creatively, not just, for example, in the cooling off period, but at various stages in the process where they see the opportunity to mediate productively. We've had a lot of interest in transparency. Another topic that was controversial for many was third-party funding, but we have included a provision addressing the disclosure of third-party funding. We have a standalone provision on security for costs, and we have created a revised additional facility that notably will allow regional economic integration organizations to act as a claimant or respondent as the REIO, which I think obviously is important for the European Union, but we can hear the example of the African Union, and I think this is increasingly a way in which states are entering into their treaties. So that is very timely. To close up, as I said, we hope that we will be sending out the final version in the next months, and that early 2022 will see us with a vote and hopefully adoption of the package. So to use the analogy of running for James, we are jogging very quickly towards the finish line. And once this is approved, we will apply it to all newly registered cases. So I think it is a very positive thing. Just one concluding remark, which is there is very strong support for this, but one of the reasons we're really pleased that we're coming to the finish line is that we recognize that delegates have a lot on their plates. And it's frequently the same delegates who are doing UNCITRAL and UNCTAD and the Energy Charter Treaty and the ICSID process. And that's good so that we can avoid fragmentation. But I want to thank them, knowing all that's been on their plate, for the really active participation that we have had. So I will stop there, but thank you very much for this opportunity.
Thank you, Mrs. Kinner. Well, I have to agree, a lot of us have to juggle with different forums, but so far we are making it possible. Our next speaker is Mrs. Anna Novik, head of the investment division in the OECD. Mrs. Novik, based on the recent discussion at the OECD, how do you see the future of investment treaties? And what is needed for IIA reform?
Okay, thanks, Samira, and also thanks UNCTAD for the invitation. Good afternoon. It's really on behalf of the OECD a pleasure to be with all in this conference and with many of my friends and speaker colleagues. We are in this conference taking stock of all reforms and also discussing the way forward in the next session. And we have begun at the OECD a kind of forward-looking view to reflect on the future of investment treaty, what future treaties should look like, and whether all the treaties should be made like more recent treaties. And I would like to answer your question, Samira, but with some context, because I think that it's good that we recognize that in the last years, many countries have experienced public expression of discontent about treaties, and we have been it's difficult even to go to Congress with these kind of treaties. Demand from the midst of society have led government to engage in improving multilateral work on certain specific issues. And this is what we have been listen from Meg. We will probably hear this from Andrew Van. And also I think that this is the effort that many of you are doing in the Energy Charter. Also, I think that the WTO are seeking to agree on this way to facilitate investments through the encouragement of improved government procedures. And I think that also this is something very positive in a way. This work is important, but leaves out two important issues. One, a broader forward-looking and global reflection of the future investment treaty. A second, a reflection of what to do with existing treaties. The OECD launched last March in this treaty conference a two-track approach to deal with these two issues, complementing what they're discussing and trying not to put more burden on delegates, but to make the other two issues that are missing here. Under track one, we are identifying policies that could be addressed by future treaties on investment. The debate needs to reconsider traditional interests and respond to today's broader global challenge. Some areas that we are considering are foster sustainability development, responsible business conduct, including human rights, notably through attention to policy to maximize the positive impact, provide also framework for investment market access and facilitation, as was mentioned by Carlos right now, ensure sufficient regulatory policy space also, that this is something that countries are also looking for, and implementing a more flexible range of remedies and procedures in the way that Meg just mentioned. There is one important area that is urgent, the need for treaties addressing investment to support and not impede non-discriminatory climate policies. In the debate of the future of treaties, economies not only need to consider a broad range of possible, more flexible treaty model, but also whether other tools are better or need to be better to complement the treaty part. The second aspect of this is the reflection is what to do with existing treaties. We know that bilateral investment treaties and investment chapters in preferential agreements are evolved. We have this, new designs are bringing greater precision and clarity, but these changes do not apply to over 3,000 existing treaties. When we talk about the treaties that governments already have, we implicitly refer to the treaties that were concluded earlier, as was mentioned by James at the beginning. The design of certain clauses in these treaties is no longer used and has been replaced by newer design. The changes that countries have made to their design since the early 2000s endeavor to clarify and calibrate treaty obligation. What we are doing in the Track 2, the OECD has just released a document that I will advise to see because it's a more evidence-based, and it's the evolution of the science of provision to allow governments to assess the situation. Reflection on the merit of applying more recent practice to older treaties. We have been focused on evidence for 3, indirect expropriation, fair and equitable treatment, and most favored nation. And because these items are to correspond to the clauses that are associated with the largest number of claims and probably the more controversial decision in treaty-based litigation. We have collected all this treaty in 80 economies and have concluded with different countries. And let me very brief some observations. First, there is some diversity in details, but most of all very significant similarities in treaty design today. Clauses used today are more specific, more circumscribed, and testify of a desire to calibrate and cap the obligation that they contain. That applies to all 3 clauses. Second observation, the new practices is consistently applied in all new treaties. However, the proportion of adoption for new treaties or new design clauses is low. For example, indirect expropriation first emerged in 2003 and has been gradually become the standard in newly concluded investment treaty. More than 60 of the treaties concluded since 2003 contain the notion of indirect expropriation. However, the feature is rare among the entire population of treaties. When economics use the feature for the first time, most of them use them consistently. However, and this is my final observation, also the new designs are consistently applied. The old treaties with the old design do not go away. Even though new designs increase, the diffusion into the treaty population is very slow. Countries have essentially 2 treaty populations in parallel. Old design, around 80–90% of the overall total, with significant difference among countries, and new design, 20%. 10–20. This proportion is unlikely to change significantly under the current course. What could one conclude from this evidence? First, one could wonder whether countries would want to apply what they now show they think is right to the many older treaties whose text would probably not agree to today. One could also wonder whether the common intention and similar approaches in these clauses offer an opportunity to apply new design. There is an opportunity to retrofit older treaties, maybe collectively. The OECD provide a new platform. I know that UNCTAD also, we have different platforms for that, but I want to invite you to engage also with our work at the OECD, and we will try, frankly, to do it in a way that will not put more burden, but help and complement the other processes that are currently on happening. Thanks, Samira.
Thank you, Anna. Now we will hear from Mrs. Anna Joubin-Brett, Secretary in the UNCTAD. Anna, UNCTAD Working Group 3 is working on the reform of investment state dispute settlement. Where does the process stand and what are the next steps? Please let us hear you.
Thank you very much, Samira, and thanks to the friends and colleagues in UNCTAD for giving us the floor and allowing us to brief you on the advance that we've been making in UNCITRAL. And I'm pleased to say that in spite of all the difficulties of the last months, the progress has been steady. We are now in our third phase of the mandate, and we are in the building, in the actual delivery phase of this reform. I should say that anything you want to know in more detail, because I don't have much time, you can find on the UNCITRAL webpage, particularly on the Working Group 3 page, where you have absolutely every paper, contribution by states, contributions by IGOs, NGOs, everybody's contributions, comments, everything is there. So very briefly to tell you where we are currently and what we expect, where and how we expect to land the process. So we are currently, as I said, in the delivery stage. So we are working on various reform elements, some of which are more of structural nature, and I'm talking here about the multilateral investment court that the European Union has presented as an option, has put on the table as an option, and also on the establishment of an appellate mechanism that would work not only as a second layer or second tier for disputes brought to the investment court, but also would apply to disputes that have come through investment arbitration. So this is where we have, of course, still a lot of fine-tuning and a lot of technical issues to solve, including treaty law matters. And the third element of structural reform is the establishment of an advisory center for developing and least developed countries in order to help them to navigate the system more efficiently and more also cost efficiently, and also by doing this building capacity. At the same time, the working group is advancing also on many procedural reforms, some being more, I would say, small in the size of the text that we are working on, and others more broader again in the text. We have work that is underway on third-party funding. We're going a bit further than our colleagues from ICSID in the sense that we're also looking into the possibility of simply barring third-party funding in investment arbitration, or putting conditions on the possibility for third-party funding of claims against states. We're also looking into matters such as the development of a code of conduct, which is the one that is going to be ready quite soon, as the next session of Working Group 3 is going to spend a week finalizing the third reading of a document we have produced together with ICSID. And it's been a pleasure working with our friends and colleagues in ICSID on that. We are working on counterclaims for states. We're working on also, and I would like to emphasize this particularly, a number of so-called cross-cutting issues, which have been again very clearly emphasized by developing countries in the last Commission session, saying that we shouldn't end up rearranging deck chairs, but that we should really enter into those fundamental issues, although our process is not a substantive reform process. But still, there are matters such as, for example, the calculation of damages, standards for damages. There are matters such as the need to give way to forms of exhausting local remedies, the possibility to also, through the dispute settlement system, to produce to bring these cases to an early end. And the third and last thing I would like to emphasize is the delivery mechanism on which we are working, and which brings me to answering your question, in the next 4 years, we expect to have finalized each of these different elements of reform and to be able to bring all of this together under the umbrella of a multilateral treaty, which will contain all these reform elements and a number of protocols for those who don't want to. It's going to be sufficiently flexible so that not everybody will be part of everything, except for a common set of reform elements that will apply across the board. So that's really what I wanted to say, thanking you for this opportunity, and also thanking all the states, because it's a state-driven process, for accompanying us, including into the acceleration that we will be facing from now to 2026. Thank you very much.
Thank you, Anna. We all know that Working Group 3 is very busy, and we are looking forward to working with you on the issues that are on the table. Our next speaker is Mr. Moritz Luhmann, Head of Division for Foreign Investment in Germany. Mr. Luhmann, what are the priorities for Germany for the reform of the BITs with the world and for IIA's reform more generally? You have the floor, Mr. Luhmann.
Thank you very much, Ms. Sulemanovic, and many thanks to UNCTAD for organizing this important exchange on IIA reform. The COVID-19 pandemic has, on the global scale, mostly affected those working in low productivity sectors, in particular in developing countries, which worsens inequality. As estimated by UNCTAD, the cumulative value of recovery funds worldwide consists in some $3.5 trillion and could attract additional private funding up to $10 trillion in total. Most of the funding for the recovery has been earmarked by developed economies and a few large emerging markets, and developing countries account for only about 10% of the total stimulus spending. But post-COVID-19 recovery investment packages are likely to shape global investment patterns as a whole. The question is how to gear investment flows in a way to contribute to sustainable development goals and climate protection. And in our view, investment facilitation and IIA policies are both two obvious key drivers. Germany actively supports the WTO negotiations on investment facilitation. And IIAs are an important pillar of the international rule of law. IIAs are a substantial legal asset for countries to attract foreign direct investment as part of their economic development strategies. Germany and the EU stand for the most comprehensive AI reform ever undertaken, and I would like to emphasize two features. First, the right to regulate, and second, a transparent investment court system which overcomes the deficiencies of arbitration. Firstly, the state's right to regulate should explicitly and in detail be incorporated in modern IIAs in order to help states understand how they can undertake necessary action for the public good whilst not discouraging investment flows. And secondly, in Procedural Working Group 3, Germany advocates together with the EU and other EU member states for the creation of a multilateral investment court to replace ISDS tribunals. This initiative is the most crucial element in IIA reform. Only a permanent court with full-time judges can guarantee independence, legitimacy, predictability, and transparency of ISDS. We believe that the modernized EU approach on IIA fully serves international shared policy objectives to foster productive and sustainable investment worldwide. Thank you very much.
Thank you. Thank you, Mr. Luhmann, very much for your insightful statement. Our next speaker is Mrs. Cindy Rayo Zapata, Director General of International Trade in Services and Investment in Mexico. Could you please tell us Mexico is a party to two of the largest mega-regional IIAs, that is USMCA and the CPTPP. So for Mexico, what can be achieved for IIA reform through regional approaches? What are the challenges you find?
Thank you very much, Samira and the UNCTAD, for having me today. Mexican treaty practice through the adoption of regional approaches has an effective way to achieve reforms in international investment agreements. And as you mentioned, the best examples are the USMCA and the CPTPP. Mexico's treaty practice in the last years has been focused on a regional approach. And to show this, there is no better example than the CPTPP. The CPTPP did not only demonstrate that several different countries with different backgrounds and views were able to successfully draft a modern investment treaty. But what matters the most of this example is that the CPTPP incorporated important improvements to the regime of the international investment agreements, which are mostly aligned with the reforms proposed by UNCTAD and which also try to address the concerns that have been rising the last years regarding the investor-state dispute settlement system. And just to mention a few of such improvements, the scope of the CPTPP and its standards of protection were carefully reviewed and clarified in order to safeguard the balance between the need to protect investments and the rights of states to regulate. And in this regard, the CPTPP included, for example, an annex on public debt, an annex on expropriation, which already seem to have become a standard in the model of countries which are not even part of the CPTPP. And we could say also the same of several improvements on the ISDS system, such as the expeditious review of frivolous claims, time limits for filing a claim, among others. So a regional approach has favored the improvement and modernization of such agreements. And the result of such negotiations has served as an inspiration for future drafting of possible solutions to address the main reforms features. And let me give you another example. 80% of the USMCA investment chapter, including the ISDS, is based on the TPP or the CPTPP investments chapter. And during the negotiation of the TPP, the influence of NAFTA and the NAFTA case law was also a constant factor. Of course, the main challenge that this exercise faces is that there are still substantial different views among different blocks of countries on issues related, for example, to the minimum standard of treatment, and above all, the investor-state dispute settlement system. However, we believe that we are witnessing a unique moment in which the regional negotiations are becoming a fundamental engine to standardization of international investment agreements and for the reform to enhance systemic consistency and predictability of the ISDS awards and in general of the international investment regime. And I will stop there. Thank you very much for your attention.
Thank you very much, Madam Rael Zapata. I hope that applying the approach you just told us about, we will make the necessary consistency of the IIA regime across the world in different treaties that we negotiate. Our next speaker is Madam Caroline Colo, Director from Trade Policy and Economic Governance from the Netherlands. Madam Colo, would you please tell us what are the top issues of the IIA reform of the Netherlands? What are your country's policy plan for the reform of the BITs with the world? Madam Colo, you have the floor.
Thank you very much. let me be clear that investment is a very integral and important component of our economy. We're an open economy and one of the countries with the highest FDI in the world. In the Netherlands, as I'm sure you are aware, we feel that the current system of investment protection is in need of reform. Criticisms in the Netherlands on the current BITs has increased over the past years. You'll hear specific critique on the arbitral proceedings and the general lack of transparency, as many of us have mentioned before. Also, some are opposed to the entire concept of supranational investment protection. Although we value the ISDS, we recognize that the proceedings in the old style BITs are not transparent enough and the right to regulate can be strengthened. Like many other countries in the EU, the Netherlands wishes to renew its stock of BITs. They are eventually to be replaced by modernized treaties that reinforce the right to regulate while still safeguarding investor protection and facilitating investment. In 2019, we have finished the reform of our model text for a new BIT, and that text includes some important changes. It will exclude letterbox companies. It protects the right to regulate. It makes an explicit reference to sustainability and responsible business conduct. And it takes into account the need of SMEs. While our text continues to offer high standards of protection to investors, it also imposes on them the obligation to comply with the laws and the regulations of the host country. Moreover, this model text proposes reforms to the dispute settlement mechanism. Arbiters in the future would not be chosen by the parties to the dispute, but rather by the Secretary General of the Permanent Court of Arbitration or by the Secretary General of the ICSID. Also, the text introduces high standards of transparency and diversity in their selection. Operationally, our biggest challenge is the number of agreements that we have. We have some 70 BITs in operation. This means that renegotiating each and every one of them will take an enormous effort and an enormous amount of time. The lockdowns owing to the pandemic haven't helped this situation. Many other countries, I'm sure, face the same problem. So we have a ways to go. On a broader scheme, the Netherlands actively supports reform of the international investment agreements through the EU, as well as multilaterally. We support the work of the Commission to include ISDS reform, sustainability, and responsible business conduct in its negotiations. It includes our full support to the efforts to establish a multilateral investment court. Multilaterally, we support the work on the ISDS reform by the UNCITRAL Working Group 3 and ICSID. Thank you.
Thank you very much, Madam Colo. Well, you mentioned something that is really a headache for negotiators around the world, that is replacing the old generation BITs. As Mr. Pettinato mentioned earlier, they are on the way to replace 57 BITs from the old generation. So let's hope we move forward with this. Our next speaker is Madam Farina Mazhar, Secretary from the Board of Investment in Pakistan. Pakistan has recently agreed on a new model BIT template prepared with the assistance of UNCTAD. So, Madam Mazhar, could you please tell us what are the most important reform features of the new model and what are your country's next step in the IIA's reform process? Madam Mazhar, you have the floor.
Thank you, Samira. Let me just also thank the organizers of the World Investment Forum for arranging such a wonderful gathering. I'm also thankful to UNCTAD for assisting us in the review and analysis of our previous BIT template, also the drafting of the new one. And it was indeed a very long process, and it involved research, consensus development amongst the stakeholders, and presenting the strategy and the template to the cabinet for approval. So, everybody knows that Pakistan is the pioneer of BITs, and the first ever BIT was between us and Germany in 1959. And now, currently, we have around 53 BITs. So the government today around the world are facing pressing and controversial questions relating to their BITs and are rethinking their approaches to those agreements. I think the general perception is that the BITs have not been as instrumental in getting as the much needed, the foreign direct investment. As a result, unilateral terminations, I think, are taking place. We in Pakistan also have the same concerns. We have this in mind, and we developed the new BIT template so as to allow and protect the genuine and the sustainable investments in the country. Our preamble for the BIT includes attainment of the Sustainable Development Goals, social inclusion, employment generation, reducing inequalities, poverty alleviation, protection of human rights, maintenance of health, labor, and environmental standards, and also corporate social responsibility, apart from promotion, facilitation, and protection of investment. In the new template, we have differentiated between a short-term contractor and a long-term investor, a rail company and a mailbox or shell company. We will protect all the investments of the real long-term investors. To restrict the broader interpretation of treaty provisions, we also placed provisions relating to joint interpretation of BIT provisions. To deal with the investor disputes, we are establishing forums to address grievances before they escalate to disputes. Also, a new dispute resolution mechanism has been developed. We will establish a joint committee of the contracting parties for the administration of BIT and resolution of dispute. The joint committee will be empowered to establish ad hoc working groups to discuss and resolve investment disputes. Under the treaty, both sides will notify investment focal points to resolve complaints, grievances, etc. And an office of the Ombudsman will be set up to support the investors. The Ombudsman will issue binding decisions within 24 hours. We've also provided the option of international arbitration in case if a dispute is not resolved through domestic dispute resolution forum. We've carefully fine-tuned all the BIT provisions so as to provide clarity, continuity, and also consistency to the contracting parties as well as the foreign investors. For the next steps, we are going to renegotiate all the BITs on the new BIT template, and we have initially received very positive response from our BIT partners. They also appreciate the objectives of the new template, and they are appreciative of this because of the fact that they're also experiencing the same concerns. In parallel, we're also reforming our overall investment policy and legal framework, for which UNCTAD has agreed to assist us. Using this forum, I would like to advise all the investment promotion agencies to use the resources of UNCTAD to reform their investment policies and BITs for attracting responsible and sustainable investment in their countries. Thank you so much.
Thank you very much, Madam Mazhar. It is very interesting and I would say beneficial for all of us to hear how Pakistan has been managing the reform in its own country. And now we go to my dear friend, Kekheletso Mashigo, Director of the Department of Trade, Industry and Competition of South Africa. Kekheletso, what is the South Africa's current approach to IIAs and IIA reform process? Please let us know.
Ms. Mashigo, please unmute your microphone. Unfortunately, we cannot hear you.
Oh, pardon me. My
Many
apologies.
thanks.
My apologies.
I'd like to say, again?
Yes, I will indeed. Thank you, Samira, and good morning, afternoon, and evening to all. As you may be aware, in 2008, 2019, South Africa initiated a review of its BITs. Essentially, South Africa questioned the benefits of BITs. We felt this was necessary to assess, firstly, the role of investment in South Africa, the implications and risks of entering into BITs and IIAs, and the substantive shortcomings of provisions of current BITs and IIAs. And then after the review, we took stock and identified problems. We developed a strategic approach and action for reform. We ensured an inclusive and transparent reform process. We implemented the action. And lastly, we suggested deeper reforms to reorient the IIA regime towards sustainable development. And then since then, South Africa has developed a new investment policy framework. We've terminated bilateral investment treaties, and we've adopted a National Investment Act for South Africa. Thus, our view today is that the question is not whether or not to reform, but about the what, how, and the extent of such reform. So South Africa follows an investment for sustainable development approach, which recognizes that while FDI can make a positive contribution to sustainable development, the benefits to host countries are not automatic, and instead, regulations need to be purposefully built into the investment regime and development agenda to balance the economic interests and ensure investments make a positive contribution to sustainable development. Our approach is that there's a pressing need for systemic reform of the global regime of IIAs to bring it in line with today's sustainable development imperative. We therefore approach IIA reform holistically rather than piecemeal, as we believe that it is only systemic reform that will allow addressing the concerns identified in the investment regime in a comprehensive manner. So we believe that piecemeal reform will not work. And indeed, as UNCTAD itself has for many years advocated for a systemic and sustainable development-oriented approach to reforming the international investment regime. Important in our approach, though not exhaustive, as I mentioned them, is firstly, the preservation of the state's regulatory space. Secondly, focusing on sustainable development, which for us means a conscious recognition on our part of the principle of sustainable development through promoting and facilitating investment and ensuring sustainable investment. It also means locating IIAs in a wider context of sustainable development and aligning national and regional development aspirations. Additionally, for us, this means undertaking systemic, sustainable development-oriented reform. Thirdly, it also means reforming of investment dispute settlement by looking at other alternatives to ISDS, be it exhaustion of local remedies, including domestic courts or state-to-state dispute settlement. Fourthly, it means ensuring that IIA reforms are aimed at promoting the development of inclusive investment-related dispute settlement alternatives. And lastly, it also means drafting provisions that are aimed at minimizing exposure to investment arbitration. And Chair, I think for purposes of saving time, I think I'll stop there and thank you.
Thank you very much, Keke, for your understanding and for sharing the information with us. We know that South Africa has been very active in the multilateral reform fora, so we are looking forward to see how it is working in practice. Our last but not least speaker for the first panel is Mr. Felix Imhoff, Deputy Head of International Investment and Multinational Enterprises Division in Switzerland. Mr. Imhoff, could you please tell us what is the Switzerland approach to IIA reform? And do you have plans to modernize your country's old generation IIAs like other countries?
Thank you, Chair, and good day and good evening to everyone. And please let me echo previous speakers for thanking UNCTAD as being one of the leaders in the IIA reform efforts. First, I should mention that Switzerland has one of the biggest IIA networks in place. It's also among the countries that attract most FDI. Swiss enterprises are also among the biggest investors abroad, and in our experience, IIAs provide additional legal security for foreign investors that look to invest. Now, the Swiss IIA network is renewed on a step-by-step basis. This renewal contains the elements set out in the IIA Accelerator desire like more precise definitions and standards such as FET in direct expropriation, but also the right to regulate, provisions on sustainability, and then also more comprehensive ISDS provisions. Now, on the one hand, we aim to fill contractual gaps that have arisen due to the termination of agreements. In this regard, we are currently conducting IAA negotiations with 2 countries. On the other hand, Switzerland is also conducting negotiations to replace old IAAs with new ones. And here we are currently conducting negotiations with 3 countries. In addition, it is planned to start negotiation to update an agreement with a 4th one. The ECT, which has been mentioned by Secretary General Rusnak before, can also be mentioned here, as it contains investment protection and ISDS provisions that should be updated, and elements like the right to regulate and sustainability provisions should be integrated, and we much support this update. Now, in general, the conclusion of new IIAs has become more complex in recent years due to there are also more provisions that have to be negotiated, and it requires more time, but also more resources to do so. Despite this, we have been able to make progress in their concluding negotiations with countries. In parallel to the negotiations of IAAs, Switzerland is actively involved in several multilateral processes aimed at reforming international investment protection and investor-to-state dispute settlement. These processes include, in particular, but not only, the ICSID and UNCITRAL work. These multilateral processes take a bit longer than bilateral IAA negotiations. However, the result achieved can in principle be applied to a larger number of states and agreements, for example, by the means of a convention. This makes this type of multilateral reform very effective, and this is also why we're devoting quite some resources to such discussions at present. Thank you very much, and I look forward to the further discussions.
Thank you very much, Mr. Imhoff. Basically, on what you just said to us, I'm glad to hear that we all at different parts of the world are heading the same direction with minor differences, and that will hopefully result with the consistent system of the IIA's regime in the future. One of the forums that is enabling all of us to do such thing is UNCTAD, among others, and I thank our IIA team for enabling us to do so. Thank you, all the speakers in the panel 1 for sharing your experiences and information with me. We stick to the time. We just 2 minutes over the time, so good for us. I thank you once again, and I hand over to my dear friend Patience, who has been patient waiting for her panel. Patience, you have the floor.
Hi, thank you very much, Samira, and thank you to all the panelists in session 1 for a very enlightening session. Good evening, everyone, and a very warm welcome from the very hot city of Abuja in Nigeria. A lot has been said this evening, about IIA reform and the need to take stock on the reforms and what is going on across the world. But we acknowledge that the length of time required for these reforms, as useful as they are, the length of time required for the reforms is very critical, because that will make sure that we're not stuck with the old generation regime of the IIAs that a lot of people have agreed needs some kind of reform. So the next panel will be dealing with this issue. It will be looking at IIA reform, the way forward, accelerating the reform process. And I'm delighted to announce that I have a very distinguished panel of very knowledgeable people with experience in these issues that will be sharing their wide range of experiences and perspectives on the issue of accelerating IIA reform. I'll quickly like to introduce the panelists before I get down to asking them questions. We'll have on the panel Mr. Windad Quadflish. He's the chair, Committee on Investment and Responsible Business Conduct, Business at the OECD. We have Ms. Chantel Ononewu, of the Trade Policy and Legal Specialist, Office of Trade Negotiations, CARICOM Secretariat. We also have on the panel Ms. Lisa Sachs. She's the director in the Columbia Center on Sustainable Investment. We have Dr. Susie Nikema, Sustainable Investment Lead, Economic Law and Policy Program of the International Institute for Sustainable Development. Also with us is Mr. Jensen Kalamita, the Head of Investment Law and Policy, Center of Investment Law and Research Associate Professor in the Faculty of Law of the National University of Singapore. Also with us is Mr. Surya Deva. He is the chair of the United Nations Working Group on Business and Human Rights and a professor at the Macquarie Law School, Sydney. Mr. Sean Donnelly is a senior advisor of the United States Council of International Business, and he's on the panel as well. I also have, last but not the least, Professor McCain Beng. He's the professor of international law and the director of the Department of International Law in the University of Geneva. I would like to welcome all the panelists and to just reiterate the points that Samira made earlier. All of you are experts in your field, and I understand that it will be a bit of a challenge to get you to speak on your experiences just for 3 minutes, but we trust that you will be able to, to give an overview that will interest the participants sufficiently to follow up with questions even after this forum is done. So I'll quickly request that we adhere to the 3 minutes, after which we will have further time for interventions. I'd like to invite everyone to join these very engaging discussions. And I'll start with Mr. Winard Quadflish. What role can businesses play in the worldwide processes to reform IIAs? Which elements of the reform are particularly relevant from a business perspective? Please go ahead.
Thank you, Patience, and thank you for giving Business at OECD or BIAC the floor to present our views. And it is great, of course, to see so many old friends and acquaintances in this program of today. I will first make a few remarks on today's international investment climate, and then I will address 3 key policy issues. In nowadays international investment climate, 4 elements are key. The first is that FDI is recovering from the COVID crisis, but in a very uneven way. UNCTAD numbers show that infrastructure is booming, but investments in industry and supply chains lag behind. High-income countries are well recovering, but FDI in middle-income countries recover too slow, and in low-income countries even shrinks. The second point is that investment needs are massive due to the green and digital transitions, COVID recovery, and health demand. Fostering them is important, and the OECD has some important policy instruments to that end. My third point is that the political climate is rapidly changing. Keywords are now not so much market liberalization and growth, but rather geopolitics, resilience and reshoring, a shift from rules-based to power-based, international relations, state-owned enterprises, investment screening and national security, export controls and decoupling. This is a new world where IIAs gain in importance. And my fourth point is that the climate for FDI discussions is better, in my view, than some years ago. At times, it was so emotional that rational arguments were often drowned out in the noise. Let me now turn to your question, Patience, on what role business can play in the reform process of IIAs. The UNCTAD's first reform policy pillar is the right to regulate while providing protection. I think that is really the key question, the combination. Of course, in principle, governments must have the possibility to regulate. But there is always a risk of disguised protectionism, and motives behind regulation are not always completely justified, especially in countries with government deficits. So there must be a real balance, and I think Caroline Colau and Moritz Luma also indicated that clearly. That is also the simple reason why IIAs exist, to provide justified protection. In the international investment climate of today, investors are confronted with increasing uncertainty. This is holding back much needed FDI, and business needs IIAs and the transparency and certainty they provide. The second policy issue I would like to address is reforming investment dispute settlement. In this field, we have some years of extraordinarily heated debate behind us. In that environment, the EU developed its proposal for an ICS. It is a very innovative proposal, still surrounded by many questions. While these discussions continue, it is important also to look at ways to reform ISDS, and various speakers addressed this today, among them ICSID and UNCITRAL. A series of valuable proposals have been made to address questions concerning the code of conduct of arbiters, the cost and time of procedures, appeal procedures, increased transparency, non-discrimination, fair and equitable treatment, and the right to regulate. This opens the door for meaningful reform and modernization of ISDS. And my third and last point is on ensuring responsible investment. Responsible business conduct is the logical complement of an open international trade and investment climate. Many proposals for strengthening RBC are now on the table in the OECD, in the EU, and elsewhere. And we at BIAC intend to participate fully and constructively in these processes. Thank you.
Thank you very much, Winad, for your thoughts, and we appreciate the work that BIAC is doing. I'd like to move now to Chantel. Chantel, you will play a very active role in the reform of IIAs at the CARICOM Secretariat. Can you share with us the practical roles that the CARICOM Secretariat plays in facilitating the reform of old generation IIAs of its members? Chantel, over to you.
Thank you so much, Patience. Again, I must thank the organizers for the invitation to participate in this conference. CARICOM is supporting the reform of the old generation investment treaties of its members in several practical ways. I'm going to just briefly touch on three. The first is facilitating consultations or deliberations among its members on investment treaty reform. The second practical way is facilitating training and capacity building in this area. And finally, it's providing technical assistance and support to individual countries, member countries that are pursuing reform of their existing investment treaties. To turn to the first practical way in which we are supporting reform of our members' existing IIAs, it's facilitating consultations or deliberations and thereby giving visibility to this important issue. So to give an example, back in 2019, the Secretariat co-organized with UNCTAD, the International Institute for Sustainable Development, and the Commonwealth Secretariat, a CARICOM forum on international investment agreements. And officials that who participated in that forum, they developed recommendations concerning review of the costs and benefits of their treaties, their country's treaties, options for reform of these treaties, and very importantly, preparatory actions for reform. The officials' recommendations were actually brought to the attention of ministers through CARICOM's Council on Trade and Economic Development, and there was agreement that strategic priorities of CARICOM countries with respect to investment treaty reform would be determined. Turning to the area of facilitating training and capacity building on investment treaties. Again, in conjunction with other partners like UNCTAD, CARICOM has facilitated the training of officials. And what we've sought to do is tailor this training or capacity building in a way that would enhance the knowledge that officials have of generally the governance framework for investment, not only investment treaties, to help them understand the key protections in investment treaties, how they're interpreted, to let them understand the current design of investor-state arbitration, and importantly, to share the experiences that their own countries have had with investor-state dispute settlement. These capacity building initiatives have also been focused on options for reform of investment treaties and investor-state dispute settlement, and sharing on reform initiatives that are being pursued at various levels. And the importance of such training or capacity building is that it better positions officials to review the content of their own treaties in terms of the risks and benefits that they pose, and therefore to make informed decisions with respect to the pursuit of options for investment treaty reform. Finally, I'd just like to highlight the role that CARICOM plays in providing technical assistance, technical advice, and support to individual countries that are pursuing reform of their investment treaties. We have provided support, we continue to provide support to individual countries that are undertaking reviews of their investment treaties and considering options for reform. And we often do this by also assisting them to examine the approach that are taken by the partner countries in their own national models or treaties with other states as an important preparatory action for investment treaty reform. The Secretariat has also developed tools such as the draft CARICOM template for investment chapters in external trade agreements, which is far more sustainable development oriented than the older generation investment treaties. And this template can be used by member states as a reference when they're examining options for reform. What I would just like to end by highlighting how we found to be valuable UNCTAD's policy tools, including its more recent IIA Reform Accelerator, when we do provide technical advice and support to our member states with respect to investment treaty reform. So thank you again for the opportunity to share the experience of CARICOM in this regard.
Thank you very much, Chantel, for the experience. And I have to agree with you that UNCTAD's tools have been very valuable for a number of countries in reforming the IIA process. I'd like to move now to Lisa from the Columbia Center of Sustainable Development. Lisa, you have been very involved as well in these processes towards reforms. Looking at the many reform approaches that exist, what paths in your view towards reform seem to be the most promising? What parts of them are the most promising from your point of view? Lisa?
Thank you so much, Patience, and to James and to our colleagues at UNCTAD. It is so fun to be among so many friends and to get to hear this whirlwind of really motivating updates. So I'm grateful to have been included and really delighted to have heard all of these updates. I know that all of us on the call agree on the critical role of investment in meeting the Sustainable Development Goals. Mobilizing this investment and ensuring it aligns with our sustainable development objectives requires a robust policy framework that supports governments in attracting or promoting necessary investment and finance, in addressing critical barriers, and in strengthening the ability of governments to govern investments so as to maximize the benefits and minimize their negative impacts. I think we've now reached a pivotal recognition that existing investment agreements, even the new generation treaties, are not tailored to these objectives. I had planned to emphasize the ways in which treaties are misaligned, but indeed many of my colleagues have made these points in their remarks. So suffice it to emphasize here that existing treaties, including the new generation agreements, continue to be based on flawed assumptions about the drivers of investment and the role of domestic institutions in the complex governance of this investment. Quite aside from this misalignment, we also have partners on the call, most notably, I would say the OECD, who have done a meticulous accounting of the outsized costs of investment treaties relative to their, especially relative to their under-realized benefits. My colleagues and I at CCSI have also written on this. As James mentioned right in his introductory remarks, most existing proposals for reform ignore the misalignment of the treaties with both their original objectives as well as with our current global challenges and goals. And the misalignment and the outsized costs are not addressed by existing reform proposals, neither the procedural proposals nor the reforms of substantive provisions. So to answer your question, Patience, what I find to be most promising and most encouraging are the growing number of states, including some that we've just heard from, and their supporters, their institutional supporters like UNCTAD, who are putting the Sustainable Development Goals at the heart of their investment policy and fundamentally rethinking both domestic and international instruments and how they can help to align investment with their sustainable development objectives. This fundamental rethinking is, we've already seen with a number of our partners, likely to inspire both creative and more effective approaches to attracting, shaping, and governing investment in mutually beneficial ways for countries and for investors. I'll just note that I think UNCTAD can continue to play an absolutely instrumental role in rethinking the international governance framework and the systemic reforms that would meet the transnational challenges of governing investment for sustainable development. UNCTAD had a wonderful report on these systemic challenges, which go far beyond anything addressed in current investment agreements. So UNCTAD's leadership in this respect has been really incredibly helpful. And we at CCSI are delighted to offer our continued support and partnership in that respect. Thank you very much, and I look forward to the discussion.
Thank you very much, Lisa. I think you made a very good point about the misalignment in treaties of the original objectives and the current realities. And you did not finish your presentation without cutting out the work of UNCTAD, but I was happy that you offered the support of CSI to help with the process. We would like to move now to Dr. Susie Nikema of IISD. Dr. Susie, you are one of the pillars in IISD that have been engaging across the world on the reform of IIAs. What, in your view, are the bottlenecks of IIAs in the reform process, and the bottlenecks in the reform process of IIAs, and what do you think we can do to solve the problems, having engaged with a wide range of countries? Susie, please.
Thank you very much, Patience, and thanks to UNCTAD for the invitation. And good morning or good evening, dear colleagues and friends. To respond to your question, I think at least two bottlenecks could be highlighted here, which both relate to the issue on coherence. The first challenge is the disconnect between IIA's reforms and other governing legal instruments at national and regional levels on the one hand, and the disconnect sometimes between substantive and procedural rules on the other end. Indeed, IIA's reforms that are scattered might exacerbate existing problems. It is therefore important that we define ambitious reforms and solutions to IIAs while ensuring IIA's reforms are aligned with domestic laws and regional instruments, as well as investment contracts where relevant. The second challenge is to ensure that IIA's reforms go hand in hand with other treaties governing investment-related issues, such as those regulating the environment, public health, or human rights. It is key to develop greater coordination here between government officials who negotiate various but interconnected international instruments to avoid having reforms made under one treaty contradicting or even jeopardizing the reform made under another one. One example I can provide here being the negotiations of a binding instrument on business and human rights at the UN level and related development on due diligence requirements. We think that IIA reforms must take this into account. Finally, it is important to recognize how far we have come here. As a pioneer organization in raising awareness, calling for and engaging in IIA's reforms, IISD acknowledged the important efforts of governments, as well as all stakeholders, intergovernmental organizations, NGOs, private sector, and academia over the past decade, several being represented today in this meeting. And notably, we think UNCTAD has played a decisive and leading role in supporting the need for reform by proposing concrete solutions. So these positive results should reinforce and encourage, we think, the UNCTAD member states and all actors involved to continue along this reform path, but ensuring that the current excitement around IIA's reforms brings us to the right destination for all people well-being. I will stop here to keep within my time allocated, and thank you for your attention. Thank you.
Thank you, Dr. Nikema, and I appreciate your understanding and keeping to your time. But I think that you made all the valid points within the 3 minutes time. You had mentioned the need for coherence at the national level, and also the need for coordination of the reforms that we're doing, such that we don't lose through the back door reforms that we're gaining through the front door. I think is an excellent point. I will move down to the academia, and I will start with Mr. Jensen Kalamita, who is also a friend of mine. Incidentally, almost all the panelists are friends of mine today, so I'm delighted. Mr. Jensen, I have 2 questions for you. First one, what is the role of the academia in the reform process of IIAs? Do you think their role can help to accelerate the reforms? The second question will be similar to the one I asked Dr. Nikema. What do you personally see as the most promising IIA reform path? Dr. Jensen.
Thank you very much, Patience, and thank you to friends at UNCTAD for the invitation to be with you today. Let me offer a few brief thoughts on your questions, and with a focus as well on the role of UNCTAD in facilitating IIA reform. At the Center for International Law at the National University of Singapore, we work closely with governments from both developed and developing states on issues related to the successful state management of investment treaty commitments. And in carrying out this work, I think it's fair to say that we rely on materials produced by UNCTAD more than any other international organization. And the reason for this is simple. Over the last decade, I don't think any other organization has done more to create tools for policymakers or their advisors, which provide both empirical insights into the investment treaty regime and offer practical solutions for states seeking reform. And in this respect, UNCTAD's 3-phase roadmap for IIA reform, I think serves to establish a really comprehensive framework within which policymakers can orient their reforms both at the national and international level. UNCTAD's work in phase 1 on designing sustainable development-oriented treaties has been instrumental, I think, in spreading awareness among states about the importance of reassessing the design of their investment treaty commitments and bringing the idea of treaty rebalancing into mainstream policy discussions. More laterally, the phase 2 work, modernizing the existing stock of old generation, I think addresses what's really still the most thorny aspect of reform. As James Zahn said at the very beginning, old generation treaties continue to cast a very long shadow and pose significant risks to states. And as we know from UNCTAD's own statistics, the great majority of investment treaty claims are brought under these older instruments. And so in this connection, UNCTAD's 2018 reform package and the 2020 reform accelerator, again, I think provide very valuable tools to address the reform of existing treaties. But ultimately, the hard work of reforming these treaties lies with states themselves. And they need to continue to summon the political will and develop the sustained technical capacity to make reform a reality. And I think that really is the unfinished work of phase 2. And in this respect, while it's encouraging to see the range of regional initiatives in which states are agreeing to recalibrated standards and taking other innovative approaches, it has to be noted that in many cases, states are continuing to undermine these very reform efforts by leaving their old bilateral investment treaties in place. And so as a result, coherence in substantive investment treaty reform really remains in many respects elusive, notwithstanding the tools that states have at their disposal, notwithstanding the work that academics might do. So I think this is a bit of a missed opportunity, and it's one that states really need to address in order to consolidate the gains of their reforms and to continue to move the regime forward in a sustainable way. So thank you very much.
Thank you very much, Jason. And I thank you for your thoughts. The point you made about UNCTAD's big brother role, which is like how I like to put it, the big brother role in moving forward with the reform of the IIA regime is a very valid one. UNCTAD's role has helped countries like Nigeria actually call our attention to the need for the reform and to handhold us through the process. It's been a very good one. I'd like to move now to Mr. Surya Deva and ask, the Working Group on Business and Human Rights just released a report on human rights compatible IIAs. What policy actions does that report recommend to accelerate the reform of the current IIA regime? Mr. Surya, please.
Thank you, Ms. Patience, and thank you also to UNCTAD for this invitation. So my response to your question will be based on this report of the working group, which I had the pleasure of writing and presenting to the General Assembly last week. And I will invite colleagues to look at this report if they have not done so yet. Probably I will put the link in the chat box after my intervention. Let me start by highlighting why an urgent reform of international investment agreements is needed. I think the current regime, in our view, suffers from 3 I's. And I start with these 3 I's first: imbalance, inconsistency, and irresponsibility. States must take, in our view, multiple measures to ensure that international investment agreements do not provide a safe harbor for irresponsible investors' conduct. And I was aware of these several reform initiatives, but because reform process takes time, it is crucial that the reforms are not symbolic. We need fundamental structural changes to this regime, which has also been exposed by the COVID pandemic. How this could be done? Building on the work of UNCTAD and others, we make 5 concrete recommendations. First, there should be a reorientation of the purpose of investment. Realizing human rights should be the core purpose of attracting foreign investment. A state should adopt a bottom-up and consultative model of investment governance, which is geared to achieving sustainable and inclusive development. Second, states must ensure that the international investment agreements do not undermine their duty to regulate. And I would like to highlight here the word duty to regulate. Many colleagues are talking about right to regulate. There's a fundamental difference between right to regulate and duty to regulate. And we need to make this shift. We need this duty to regulate because the states have an obligation to regulate under international human rights law. Otherwise, these reforms may not be good enough. States may, for example, incorporate explicitly the clean hands doctrine in such agreements. Third, international investment agreements should include investors' legally enforceable obligations to respect human rights and respect the environment, including climate change considerations. So I think this is absolutely vital. And these have to be legally binding obligations, not merely best endeavor clauses or CSR clauses. They will not be sufficient, unfortunately. Fourth, states should create access to remedy pathways for affected communities within international investment agreements. Such agreements may, for example, expressly allow communities affected by investment-related projects to pursue international arbitration claims, or they may pursue these claims in the host states of the investors. Fifth, as the investor-state dispute settlement process is not fair to all parties, and I think colleagues have made that point already, states should replace this with an alternative system which is free from defects of all these current system. The new mechanism should be able to handle all investment-related disputes, be staffed with independent adjudicators, be accessible to marginalized and vulnerable communities, deliver consistent decisions, and have an inbuilt system of appeal. So let me conclude by saying that a state must use all bilateral and multilateral openings to accelerate the reform of international investment agreements. They should make best use of opportunities offered by the UNCTAD Working Group 3, as well as the process to negotiate a legally binding instrument that is unfolding in the Human Rights Council. Thank you very much, and I look forward to the discussion.
Thank you very, very much, Mr. Surya. I think you made some very excellent points about 3 I's. And I heard you also say that it's for states to ensure that the reforms are not just symbolic, if I recall your words, not symbolic, not cosmetic, but they are actually reforms that go into the substance of the matters and the concerns of states. And I heard you say we don't really have a right to regulate. It is a duty under international law. I think those are excellent points that we can move forward with. We have heard this afternoon, this evening, depending on where you are in the world, from states, we've heard from the academia, we've heard from negotiators, and I'd like to turn it now to get the business perspective. I had told you at the beginning of this session that we'll have a wide range of stakeholders and perspectives. I'll be moving to Mr. Sean Donnelly now to ask, from a business perspective, what are the top 3 issues that should be considered in worldwide processes to reform the IIA regime?
Well, thank you, Patience. And I very much appreciate our colleagues at UNCTAD again this year. I think this is the 5th or 6th year that I've participated in this session. I associate myself totally with the comments that my colleague Vinan from the BIAC made early on. And I think it's really important to include the business perspective. I understand there's a wide range of views, and many of you may not share totally my assessment, but I think since much of the investment we're all talking about to accomplish the SDGs is going to have to come from the private sector. For better or worse, states and multilateral development organizations don't have sufficient resources. So I think the private sector needs to be an important player. And if you want us to play, you need to be conscious of what our concerns are. First, I just want to commend UNCTAD and Jane John and Jorg and their colleagues for the important work that they are doing. Even if we don't fully endorse all of the UNCTAD recommendations, the work that UNCTAD has done on statistics, on cataloging, provisions of this wide range of investment agreements is really of incredible value, and we very much appreciate it. First, I just want to make 4 or 5 very basic points. The first one is what we're talking about today is really important. Investment, and it's going to include a lot of private foreign direct investment, is the key to achieving economic growth, jobs, recovery, and the SDGs. So this really matters. This isn't just about legal questions and definitions that you can just leave to the lawyers. These matters to people, to business, but also to consumers and so on. The second is just, we need to remember investment is risky. That's what investment is. The investors putting their resources, their capital at risk. International investment is by definition riskier than domestic investment, and investors are going to seek ways to mitigate, to reduce that risk. And that's where international investment agreements come in from the investor perspective. The third point I wanted to make is that in these investment agreements, fair and balanced agreements with strong dispute settlement provisions are essential for investors. Fourth point I just want to make is to note that we've heard a lot today about the European Union's proposal for a multilateral investment court as a solution. I just like to note that, at least from my perspective, there are a lot of questions, and I think it's a really flawed proposal, and it's going to, at least there's many of us in the business community who are worried about a shift from a balanced arbitral procedure to a more bureaucratic, more government-dominated investment court. I worry about what the impact on real investment will be. And then finally, just to say again, come back where I started, thank you for including business, because we are people who invest. And if you're going to have a system that's going to work, that's going to achieve these developments we want, the SDGs, you're going to need to include and listen to the views and questions and concerns of the investors. And we want to be part of that process. I think just calling something a reform doesn't make it an improvement. I think what we all want to see is improvements, and we support the efforts that are underway in ICSID and UNCITRAL. We've been participating in that, and we want to be partners with you and with everybody in taking this effort forward. Thanks.
Thank you very much, Sean. And I think you made a good point. And UNCTAD has been sensitive to listening to the pulse of business. For the number of years, UNCTAD always gets the perspective of business, and I would like to thank UNCTAD for its sensitivity in that regard. Okay, we'll be moving forward now to Professor McCain Mbeng. Professor McCain?
Yes.
Yes, I wanted to be sure because it's raining cats and dogs where I am. So sometimes it freezes a bit. So I wanted to be sure I wasn't speaking to myself. So Professor McCain, you were very central to the development of the Pan-African Investment Code. Aside from that, you have been positively restless in ensuring IIA reform across almost the entire universe, particularly in Africa and in developing countries. So I'm going to ask so we can pull from your wealth of knowledge. Where do you like to see the IIA reform process in the next 10 years? And what do you think? So there is a two-pronged question. Where would you like to see the reform process in 10 years? And then what do you think we can all do to get there as fast as possible? Professor McCain.
Thank you very much, Madame la Présidente, my dear sister, Patience, for the kind introduction. I would say, since I'm just intervening after Sean, that something I would like to see in the next 10 years is a more healthy relationship between foreign investment and host states, and making sure that the investment regime leads to a win-win relationship between investments and host states. But what I would like to see ultimately in 10 years is what I would call a healthy relationship between the investment regime and the other fields of the international legal system. We need to ensure that the investment regime is no longer seen by some actors as being clinically isolated from the rest of international law. International investment law cannot go against international human rights law. International investment law cannot go against global health law. International investment law cannot go against climate change law. And international investment law cannot simply go against the right to development, which is now even subject of negotiations within the UN, in order to integrate it in a binding legal instrument. Because the IIA reform is about making the investment regime more compatible with actual concerns of the international community, and in particular sustainable development goals, I believe that governments and other stakeholders need to strengthen together reform efforts by achieving goals of compatibility, cross-fertilization, and mutual supportiveness between the investment regime and other fields. IIAs will truly succeed in facilitating, promoting, and protecting sustainable investment. The investment regime will have to be sustainable or might no longer be. What can be done to get faster? Well, Madame la Présidente, in order to get faster, governments need to accelerate not in terms of quantity, but in terms of quality. In other words, the race should not be about concluding more and more IIAs, but about concluding IIAs of better substantive and procedural quality. And for that, UNCTAD has paved the way. I believe that the UNCTAD IIA Reform Accelerator is the gold standard and show to government how to accelerate the reform process in order to push forward a new generation of sustainable IIAs. But in order to press the accelerator for investments of quality, one thing is needed more than ever, at least on the African continent. We need capacity building and we need technical assistance. Many developing countries are facing institutional, technical, and legal challenges in terms of reform, and those challenges have been exacerbated by the pandemic. So we hope that UNCTAD will continue and expand the work of assistance to developing countries, and in particular to African countries. Madame la Présidente, both you and me have been witnessing how the work of UNCTAD has been decisive to allow African states to have a stronger and better voice in investment lawmaking and take in an efficient manner the road of reform. And I want to pay, of course, particular tribute to our friend and colleague Ahmed El Kadi for all the work he has been doing in helping us since the Pan-African Investment Code, and then now going through into the investment protocol of the AFCFTA. So let's hope that the collaboration will continue in order to really ensure acceleration of the reform process. Thank you very much, Madame la Présidente.
Thank you very much, Professor McCain. Very, very well said. Very well said indeed. We reiterate again the role that UNCTAD has played in moving this process forward, and the role that UNCTAD will have to continue to play in ensuring that we get to where we might perceive to be the promised land as fast as possible. The good news is that UNCTAD is a big brother. The not so good news is that when you're a very big and a very supportive big brother, you get demands endlessly. So, but I'm sure UNCTAD has its work cut out for it. It has been an excellent discussion, and I thank all the panelists for all your interventions. It appears we have quite some time to take a few more thoughts, a few more questions. I would ask any one of the panelists who wants the floor to please just raise their hands. Otherwise, I would go around all the panelists and ask if you have any final thoughts, or if you'd like to intervene on something that someone else in the panel had mentioned, or a thought that you have that you think that the question that was asked to you has not sufficiently captured. So I'll first start by asking if anyone wants the floor. And if there's no one asking for the floor, I will ask for the floor on your account. And I will start in the order in which we spoke, because the people who spoke the first must have had enough time to think and review and come up with more comments. So I will start with Mr. Winard Quadflish and ask if you have any final thoughts, any final comments before we wrap up the session. Okay, I suppose he probably doesn't. Chantel, you're already smiling, so whatever it is that is making you smile, share with the rest of us.
No, I can't share that, but Patience, thanks so much for giving me the floor again. And I just want to use this opportunity to highlight the importance of countries. Several speakers have said this, paying attention to their existing stock of treaties. There's a lot of attention that's been paid in a forward-looking way to how countries would negotiate moving forward. What we found through our experience is that there is a woeful amount of lack of understanding there's a woeful lack of understanding of actually the contents of the existing treaties, and the training and the capacity building work that I mentioned that we've done has spotlighted that. And I would just emphasize the importance of countries devoting time to conducting a review of their existing agreements, assessing the extent to which those agreements are actually consistent with their current development imperatives, and to make informed choices going forward, having done that comprehensive review about how they will go about reforming those treaties. There are many options open to countries, but it has to start with that strategic review of the extent to which these agreements are aligned with your current development imperatives. Thank you.
Thank you, Chantel. I would like to now go to Lisa. Lisa, thank you first for all the work that CCSI does in trying to create engagements and keep these conversations going. I'd like to ask if you have any final thoughts, but just before you give us your final thoughts, I would also like to request the speakers from session 1 who want to take the floor, please feel free to do so. We recall that in session 1, we didn't have so much time to have an interactive engagement. So please, speakers from session 1, if you want to take the floor, just indicate by raising your hand and you can do so. Lisa, please.
Thank you so much, Patience. I wish I only had one comment. I have so much, but let me maybe try to pick up on a couple of things based on what colleagues have said. The first is that I think it's really important that we not see governance at the expense of investment. We all agree on the important role that investors and the businesses play in sustainable development. We should also recognize that our economy has not grown in a way that is consistent with our planetary limits, with inclusive growth, with equality, and so on, we have had a growing economy for the past century that has contributed to growing environmental crises, to widening inequality, to human rights abuses, and so on. So we need investment. We all agree on that. But what has been underemphasized for the past few decades is the critical role of governance and strengthening the capacity of governments domestically and in coordination internationally to govern investment in a way that contributes to our global goals and then minimizes consequences. So the conversation has been incredibly enriching, but it does feel like we're on parallel tracks in a way of thinking about a fundamental rethink of how to promote investment in a way that's consistent with our global goals on one hand, and on the other hand, tinkering with an existing set of treaties that are not fit for purpose. So I guess in a final comment, I just want to underscore that a rethink of how domestically and internationally we can and should be governing investment in a way that is consistent with our global goals, which include economic growth, is not at the expense of business. Business can and should and will always be at the table. But that does not necessarily mean it needs to, or even should indeed look the way that it has over the past few decades.
Okay, thank you. Thank you so much, Lisa. Thank you for your thoughts. Before I give the floor to Dr. Susie Nikema of IISD, I see that Keke, my sister Keke from South Africa, wants to take the floor. Keke, please go ahead.
Yes, thank you, Patience, and thanks to all the speakers for the very informative discussions. And I think mine is just to build on what Ms. Emily Mburu-Nora from the AFCTA Secretariat said with regards to the investment protocol of the AFCTA that is currently being worked on. I think it's important to underscore that or repeat that the investment protocol will build on existing investment treaty reform objectives that are being pursued within Africa. But I think whilst also benefiting from the support of organizations and think tanks like UNCTAD itself. And I think the ultimate aim of the protocol should be to ensure that it has the potential, at least, to become a sustainable solution to disentangling the complex web of intra-African BITs and international investment agreements and investment instruments that have been widely adopted in Africa. So I think for me, it's important that it's drafted from the perspective of an African developing country and least developing country perspective, and in light of their specific needs, which basically seek to combine attracting foreign investment with achieving sustainable development objectives. So I think it's important that a continent-wide African investment regime will have to be calibrated to the national, not only the national, but also the regional and continental industrialization and economic development plans of countries. And it will also have to take into account the key development objectives of African countries in order to be able to formulate provisions that will support the promotion and facilitation of sustainable development. And I think it's also equally important that African countries have ownership of the reform processes that are occurring within Africa and to design investment policy approaches in line with their development approaches. So that's just what I wanted to add to build on to what you already said. Thank you.
Thank you very much, Keke. I hear you, and I think you made a good point of saying that the IIAs we have should not only meet the profit expectations of investors, but also the sustainable development objectives of the host states as well. I'll give the floor now to Dr. Susie of IISD. IISD has done quite a number of research papers. You're always keeping us informed on what is going on in IIA reforms. So do you have any last thoughts?
Thank you very much, Patience. As Lisa said, I would like to say a lot of things, but I would pick up on one element, building again on the coherence issue that I think a lot of the speakers have touched in a way or another. And I think in this IAS reform process, it's important for government also to maybe sometimes take a step back and to rethink first the place and the role of IIAs they want to conclude in the existing legal frameworks, because we are talking about reforming IIAs, but it's not about just reforming IIAs to reform IIAs, but reform IIAs in line with what we are waiting from such instrument and how they interact with the domestic level, domestic laws, investment contract, and regional instrument. And I think that's something really important to keep in mind also, because that will help really design the right instrument at international level if the country want to keep IIAs as a tool for promoting and protecting foreign investment. But whatever is the final decision regarding IIAs reform, to make sure that this is aligned and this is reflected also in terms of what the country is promoting, is doing within its domestic laws, regional instrument, etc. And so this is really something important, because just IIAs cannot govern and deal with all issues regarding investment, international investment in a treaty, and domestic law play and should play an important role in that regard. So I really wanted to highlight this point also, as final thought. Thank you.
Thank you very much, Dr. Susie, for those thoughts. I see that Mr. Carlo Pettinato wants the floor. He spoke during the first session. Carlo, please.
Thank you very much, Patience. I didn't want to give final thoughts, but I have very practical questions because I listened very carefully to a lot of intervention. Now, one of the problems that we all agree on is the bulk of old unreformed investment treaties. Now, the new big initiatives, either the new African Investment Code or the CPTPP, my understanding is that CPTPP will coexist or does coexist with existing bilateral investment treaty. So, I mean, from the European Union point of view, we're trying to replace the old ones with new ones. But what is the African Code? Is that going to be an African-wide system to replace the network of old existing bilateral investment treaties? Thank you.
Okay, thank you, Carlo. I think you are referencing the investment protocol of the AFCFTA. I believe that's what you're calling the African Code. I hope I'm correct, because, except you're referring to the Pan-African Investment Code, I doubt, because that is already work done. The work that is currently ongoing is the negotiations of the investment protocol of the African Continental Free Trade Agreement.
Yes, the protocol, exactly.
Correct. Okay. So I would, I don't know if the lady from the AFCFTA Secretariat is still on the call. So either ask her or Professor McCain to opine, and if they have any thoughts on the question that was asked by Carlo.
Thank you very much, Madame la Présidente. Of course, as you know, I would not like to anticipate or prejudge the positions of our member states, of the member states of the African Union, on how they would like to deal with the relationship between the future investment protocol to the FCFTA and existing bilateral investment treaties, and in particular existing intra-African bilateral investment treaties. But the issue was already raised during the drafting and negotiations process of the Pan-African Investment Code, and I think that there was a rather strong consensus at that time, even if we were not very clear on the language that we would have to use. There was a very strong consensus on the fact that the continental investment instrument would have in the shorter term, or at least the midterm, to replace the existing stock of intra-African bilateral investment treaties, and maybe even replace or at least lead to the revision of the regional investment agreements. Now, one of the difficulties, one of the challenges we have, of course, is how to deal with extra African bilateral investment treaties. As we know, the investment protocol to the FCFTA would not have the power to just replace bilateral investment treaties concluded between African states and non-African states. But this is definitely one reflection that is there that will have to be conducted during the negotiations, since we will have to think about the implementation of the investment protocol. And to respond maybe to Carlo, maybe we will have a lot to learn from the process in the EU and all the discussions surrounding the ACMEA and other decisions. But definitely at some point, in order to ensure coherence, as Keke was saying, we will have to discuss the relationship between the investment protocol to the FCFTA and an existing stock of BITs. Thank you, Madame la Présidente.
Thank you. Thank you very much, Professor McCain. I see that we have 3 hands up, and they incidentally are the 3 speakers left on my list who must give their concluding interventions before we're done. I believe we have like 6 minutes before the session is over. If you don't mind, my calling you in the order in which you appear on the list. So we'll take Mr. Jensen Kalamita, then Mr. Suya Deva, after which Sean will give us his intervention. Please.
Thanks very much, Patience. Just to follow up on Mr. Pettinato's question, I mean, that's my point exactly, that states undermine their reform efforts, particularly with respect to existing treaties, when they enter into these large regional agreements and then leave the intra-BITs in place between them. CPTPP is hardly an isolated example. It's something very frequent, unfortunately, in Southeast Asia, with ASEAN's FTAs, with RCEP, and with the intra-ASEAN BITs, notwithstanding the fact that we have an ASEAN-wide investment treaty. I did want to address, suggest that this kind of issue is pressing, as much as it is pressing for us to reimagine the system in a global way. There are actually thousands of treaties that are still in force that are no longer fit for purpose. And before we get too caught up in reimagining what this system should be or what these treaties should look like, I think it behooves states to deal with the problem that's right on their doorstep, which are these existing treaties. In that respect, I do agree very much that the cooperative aspect of the investor-state relationship needs to be continue to be emphasized as we go forward. And I think in that respect, the moves in the WTO and elsewhere focusing on investment facilitation are aspects that can really funnel into what states are doing in their FTAs. But I would caution generally on treating FTAs as a vessel within which to deal with all international ills with respect to economic, environmental, human rights, and so forth, unless that's indeed what states seek, which is to reimagine omnibus treaties. But I'm not sure that states are there. Thanks for give me the time.
Thank you. Thank you so much. Mr. Suya Deva.
Thank you, Ms. Patience. So I'll make 2 or 3 quick points. My first point is that we should not see investment as an end in itself. I think there's a growing consensus that we need investment for sustainable development, right? But the point that the state should be asking this question very hard is that whose development are we talking about? Who is developing in a particular state, right? The level of inequalities that we see, the level of poverty that we see, the number of child labor cases that we see in the global south. These are significant numbers which raise serious questions that whether this foreign investment is really helping a sustainable and inclusive development of everyone or only certain sections of a society. So I think that is a fundamental question states should be asking. The second point is that there is no conclusive evidence that investment agreements bring investment, because investment depends upon a number of factors. So I think this narrative should be questioned as well, that you need investment agreements, otherwise there will not be any investment. And my last point is that, yes, I agree with Sean that yes, investment is a risky business and you need legitimate protection. But investors cannot create risk to the people and the planet. That is also absolutely clear in our view. And that is where the idea of mandatory human rights due diligence within European Union and as part of a treaty in Geneva is going to become quite crucial. And I think that's where McCain's point is coherence comes into picture, that the investment law has to take into account what else is happening in other regimes of international human rights law. Thank you very much, Ms. Patience.
Thank you, Surya. I see we have just about a minute and a half left, and we have 2 hands up. So I would just plead with UNCTAD Secretariat to give us maybe 1 minute or 2 more, so that the 2 hands will not have been up in vain. I will take Sean's last intervention, and I see that Felix from Switzerland also wants to make an intervention. So we'll do Sean, we'll do Felix, and then we'll hand over to you, Hamid, and your team.
Great. Thank you, Patience. I was just going to make a general point about how complicated these issues we're talking about are and how much they've changed. I think many of these treaties were drafted, but many of our mindsets were set in a day when all investment went from north to south. It was natural resources and so on, and how complex the world has gotten today, with China and India and Brazil becoming major investors in Europe, in the United States, African countries investing. So much of the investment is through different new creative vehicles in the services sector, et cetera. So just how incredibly complex this is going to be. And then I want to endorse the comment that Professor Calamita made, if I understood it correctly, about, well, there are a lot of problems in the world, and climate and human rights and all of that. To roll all those in and try to solve all of them in an investment treaty really worries me, that we'd be overloading a process that in and of itself, the investment provisions are complicated enough. So anyway, thanks for the opportunity to make a few closing remarks.
Felix.
Yes, thank you. And only a quick remark from my side. We all agree that we should build better, that we should build more sustainable. And I'm not sure that we are in a discussion on like 2 parallel tracks. Governance is key. And if governance is good, treaties lose their importance. They only give additional guarantees to investors. Other factors may be or are more important, but they're also important. Now, we should look at the sustainable investment, but also, especially before the background of the Agenda 2030 and also the COVID pandemic, we should look at how much sustainable investment can be attracted by economies. In this regard, it would be good to have further analysis on the respective investment potentials of countries. Thank you again for giving me the floor again. Thanks.
Thank you very much, Felix. And with that, we come to the end of the second session. I'd like to thank Mr. Quad Flish, Chantel, Lisa, Susie, Professor Calamita, Mr. Suya Deva, Sean, and Professor McCain for an excellent and very engaging discussion. And I'd like now to hand over the session, the program, to, I believe, Hamid El-Kadi or Diane.
Yes, thank you very much, Patience. Thank you very much. And thanks, Samira, also. Excellent moderations. So at the end, on behalf of UNCTAD, I would like to express our appreciation to all of you, our distinguished moderators, panelists, speakers, for your valuable contributions. Our gratitude also goes to all those who attended and watched the streaming of the conference in the World Investment Forum platform. The event was recorded, and so you can all see the video later on. You have taken stock of ongoing IIA reform efforts. You have shared your vast experience with us on IIA reform from government, international organization, private sector, academia, and civil society perspectives. The inclusive nature of UNCTAD's IIA conference and World Investment Forum allows us to engage openly and discuss and share ideas on IIA reform. And this is crucial to move to a more balanced and sustainable development-oriented regime. We can only do this together in a coordinated manner and a synchronized manner. As you may have heard earlier this afternoon in our Global Leaders Investment Summit, a number of heads of states and leaders from the private sector reaffirmed UNCTAD's work on IIA reform and reiterated that our objectives are on track and are extremely needed at this very critical time. So gradual change is happening as we talk. What is needed now is to, as you all mentioned, to reform in a balanced manner this aging IIA regime. I think that we all agree. In UNCTAD, we will continue to work with countries and with all of you to pave the way for a more inclusive, transparent, and synchronized IIA reform process in pursuit of sustainable development. At the end, allow me to thank my colleagues who worked very hard to make this conference a success. Diana Rosert, Vincent Bayer, Florencia Sarmiento, Natalia Ullert, Anki Wang. Thank you very much to all the team. I wish you a nice continuation of the World Investment Forum. Thank you very much. And this brings to a close this session of the WIF. We can now close the streaming. Thank you.